Okay, everyone, thanks for coming. I know it's technically Easter holidays in the academic term, so appreciate you all coming. We're delighted to have Olga Pandos, who's a lecturer in law at the University of Adelaide in South Australia, join us today. And the title of Olga's talk is The Ethical and Regulatory Implications of Emerging Biotechnologies, Perspectives from Australia. Now, Olga arrived yesterday very, very early into Heathrow and did very well to battle through. And no doubt you're probably feeling very tired, but we really appreciate you here to give this talk. And another talk tomorrow night as well. So
back to back,
yeah,
for me.
Back to back.
Yeah.
So we are going to have about 40 minutes of presentation and then plenty of time for questions afterwards. So I think we're going to wait until the end for questions because we're going to pause the recording at the end and snip it at that point. So we do have plenty of time for questions, so please feel free to chip in. We're really glad to have a really interdisciplinary crowd tonight, which is great, which speaks to the topic of Olga's presentation. So I'm going to sit down now, and we're recording, so that's good. And then we'll stop at the end, and then we'll open up to the floor. And I'm going to wander to the back to take some photos, so that's okay.
That's fine.
Okay, great. Thanks, Olga.
Thank you. Is it on? You might have to press.
Great.
All right, thank you so much for having me here tonight. And many thanks to John as well for helping to facilitate this and all the organisation that's gone behind it. So I do really appreciate that. And for peace of mind at the end, the Q&A will not be recorded, so please feel free to have a discussion, ask questions. So tonight, I'm focusing on one type of emerging biotechnology, and that is CRISPR technology. Specifically, I'm looking at heritable human genome editing. And the themes that are raised within this presentation are based upon a recent publication of mine, which is drawn from my thesis in a leading law journal in Australia. And I should note from the outset, I think the article was distributed to those who are here and who have registered. I won't be going into too much detail around the theoretical lens that I adopt in that publication. But what I will note is that I use 3 ethical schools of thought to try and justify Australia's current position when it comes to the regulation of new technologies. And what we often see, and it's likely unsurprising to you to hear this, that the law often adopts a reactionary response to something new. And often fear perpetuates this reactionary response, and it leads to a precautionary approach. But in this instance, it perhaps has gone a step too far in that it is very prohibitive as well, particularly for research contexts when we use this type of technology. So we do see that there remains quite a large disconnect between the law and sciences and how there are possibly different ways that we can try and bridge this gap. So firstly, what is CRISPR? It's probably an acronym you've come across in mainstream media, within science, perhaps within law, definitely within medicine as well. And it's an acronym that stands for clustered, regular, spaced, short palindromic repeats. It's a little bit of a mouthful, but interestingly, these were first identified in approximately 1987 by Ishino and colleagues in a prokaryotic cell, which is a single-cell organism. And at that point in time, it was reported as an unusual structure in the DNA, but they didn't actually understand why it was there and why it was recurring. Subsequent experiments showed that it actually formed part of the adaptive immunity of prokaryotic cells, which is very interesting because it means that perhaps we could exploit this sequence to manipulate the genome. And over time, we saw more and more studies come to light around the importance of these CRISPR repeats. And eventually, the Nobel Prize laureates, Jennifer Doudna and Emmanuel Charpentier, realised that we could actually use this to change sequences in our DNA. And importantly, sequences that we select. So firstly, how does CRISPR technology actually work? So here we have our DNA, This here represents the CRISPR-Cas9 complex, which is essentially the gene editing machinery that we use. Firstly, we need to insert this machinery into our cell in order to actually do its job. Various ways we can do this, through a microinjection, or it could be through a viral vector, which is essentially a virus particle that brings it into the cell. What we first need to do, though, is create a ribonucleic acid construct. Ribonucleic acid is RNA for short, and it's essentially DNA's cousin. It's a single strand. And this acts as our guide. So the guide RNA will be able to target and recognise our gene of interest. And the gene of interest could be a stretch of a DNA sequence that we would like to remove or modify. And using CRISPR, we can remove it and replace it with a sequence of our choice. So we have the guide RNA. What we also have is Cas9, this one here, which is a CRISPR-associated protein. And they act as our genetic scissors. So once the guide RNA has helped transport the complex to the specific location in the DNA that we want to cut, the Cas9 protein initiates this cut. And it does so by recognising a short sequence called the short protospacer adjacent motif, or PAM for short. Once that has bound to the PAM sequence, that initiates a double-stranded cut. And that's what this represents here. We've got two strands of DNA that now need to be repaired. This initiates the cell's repair machinery. The first way that we could repair this double-stranded break is through a process called non-homologous end joining, and that simply means that we join the two ends of DNA together. It's problematic because it's error-prone, and often the errors lead to the gene being knocked out, which essentially means it loses its function, which is not necessarily a good thing, depending on what that gene is coding for. The alternative is a process called homology-directed repair, and this mechanism allows us to exploit the ability of the CRISPR complex to insert a new DNA sequence. So homology-directed repair is generally a much more precise method, and it's less prone to errors. And if we're actually going to use homology-directed repair, what it means is within our CRISPR complex, we've got our guide RNA, we have the Cas9 protein, but we're also going to bring in a DNA sequence that we've constructed ourselves, and that machinery, that mechanism, will use that template to repair the double-stranded break. And what that means is we have removed and inserted a new DNA sequence. This is very appealing from a standpoint of biomedical sciences or in medicine. If we have a gene that is pathogenic, which means that it confers some kind of predisposition to a disease, we could remove that gene and insert a healthy gene. Alternatively, there are many instances in our DNA where we have mutations occurring. That mutation may not necessarily be appealing for our cell systems, so perhaps we could use CRISPR to correct that gene. So we restore its function back to its wild type, which just means its normal function. And generally, when we're looking at CRISPR within the context of human application, this will be done at the human embryo level. So we would be doing all of this at that point in time. So just a brief note on terminology before I get into the substantive content of tonight's presentation. Generally speaking, there are two types of genome editing. The first being somatic genome editing. And our somatic cells refer to all of our cells in our body except for reproductive cells. The key being, if we employ somatic genome editing, the edits are not heritable. They will stay with that individual. In contrast, if we look at germline genome editing, this is making edits to our DNA in our germline cells, which are our reproductive cells. So for a female, it's our ova or eggs. For males, sperm. The key distinction between the two types of techniques, when we're dealing with germline genome editing, these are heritable changes that will be passed on to subsequent generations. So any offspring coming from an individual who's had germline genome editing will inherit those changes. So this intergenerational effect and the uncertainty when we deal with unknown long-term health implications is a huge ethical concern in this space, and rightly so, because we have data deficits, we have knowledge gaps. It is very much uncharted territory in this respect. I noted earlier tonight's presentation is just looking at heritable human genome editing. Internationally now, we have endorsed terminology, and it's been shown that there's a preference to say germline genome editing can be subcategorised into heritable human genome editing. This simply means we are still using germline editing for a reproductive purpose, so to achieve a pregnancy. The second type is just purely germline editing, which is referring to using a germline cell to make an edit for a research purpose. So this is the focus of my presentation and the publication, but you'll see that there is a lot of overlap between heritable human genome editing and germline editing when we look at it from a legal and a regulatory standpoint. Okay. So if we look at Australia's position, we have been characterised as a highly precautionary and a highly prohibitive regulatory and legislative regime, to the point where we limit biological research within human embryos to such an extent that there seems to have been an imposition of a research moratorium using germline editing in particular, and it's accompanied by serious criminal sanctions if we were to attempt research in this space. What we see in Australia is that there are a triad of governing pieces of legislation, and in addition, we have other statutes and codes or policies that people working in this space need to comply with. We first have the Gene Technology Act and the accompanied regulations, the Research Involving Human Embryos Act, or the REACT for short, and finally the Prohibition of Human Cloning for Reproduction Act, or the PHCR Act for short. I apologise in advance, there's a lot of acronyms. What we have to note though, because we are dealing with a clinical application of germline editing, it would likely be as part of an assisted reproductive technique, so accompanied by perhaps in vitro fertilisation. We also need to keep in mind that we fall within the ambit of the Therapeutic Goods Act in Australia. In addition to these 4 statutes, we also require compliance with the National Health and Medical Research Council's National Statement on Ethical Conduct in Human Research and ethical guidelines on the use of assisted reproductive technology in clinical practice and research. So those are non-binding documents, but we still very much encourage adherence to those policies. If we firstly start with the Gene Technology Act, this is quite an interesting piece of legislation because it's reflecting Australia's reaction to a very new and emerging technology, and that being the use of genome editing within the agriculture and food industry. And the impetus was predominantly that exact application, agricultural and food industry, and the use of genetically modified organisms. At no point did lawmakers at the time, of course, foresee the possibility that CRISPR could be used in humans, and it was only mentioned perhaps in passing by 2 senators during debates. We see that the statutory language of the Act is very much plant-centric. There is absolutely no explicit mention of genome editing in a human context, and it is very much all about the regulation within plants. The most recent review of this Act concluded that the scheme was not designed to regulate humans. So we note that clearly some kind of federal government intervention is necessary to regulate and contain this discovery or this technology, but to future-proof the law has proven to be a very difficult task, particularly where the law often lags behind science. Can the law ever catch up to science? Can it preempt discoveries or advancements? And to what extent can it actually address those? So these are some of the recurring problems we keep encountering with new technologies. If we look at specifically the way in which our current law regulates gene technology and how it might apply to heritable human genome editing, of course there's a large degree of ambiguity in our statutory language, particularly how it applies to a human in a clinical trial context. What we see is that a CRISPR-mediated genetic modification is a gene technology under our law, and an organism that's subject to this type of modification is a genetically modified organism. So following a recent periodic review and amendments to the gene technology regulations, they introduced site-directed nuclease techniques into our regulations, and these were expanded to include CRISPR as a type of site-directed nuclease technique. That's caught within our regulations now. And interestingly, a site-directed nuclease technique, or in our case, CRISPR, one that does not have a DNA template that confers some kind of new trait or a new DNA sequence, is not a genetically modified organism. So that's quite explicit in our law. So we can make a reasonable inference that if we do have a CRISPR application which introduces a new acid, a nucleic acid template that confers some kind of a new trait or DNA sequence, this will constitute a genetically modified organism for the purposes of our Act. So that's the extent to which our Gene Technology Act addresses a possible use of this technology in humans. What we see is that our governance and regulatory framework under this Act is also quite complex and difficult to navigate. We start with the Legislative and Governance Forum on Gene Technology, which is our overarching body that oversees any type of gene technology in Australia. Underneath this, in a hierarchical structure now, we have the Gene Technology Regulator. So the LGF provides oversight to this regulator, and the regulator is essentially tasked with day-to-day operations of gene technology. And they also ensure compliance with law and regulation. Under our Act, we have two statutory ethics committees. The first being the Gene Technology Technical Advisory Committee, which, as the name suggests, comprises of scientists, doctors, and other technical experts that provide advice to both the LGF and the regulator. The second ethical committee is the Gene Technology Ethics and Community Consultative Committee, much more diverse in its membership. We have individuals with an ethics background, a legal, religious, business, public members. They also provide advice. It's not technical advice, but it's certainly advice around perhaps policy development or codes of conduct and engagement with the public around gene editing. So our primary regulatory mechanism is enforced through these four key parties, and it's through the gene technology scheme. Accompanying that, we also have a licensing regime where if a party wants to use a gene technology, they have to apply to the regulator who approves it. Again, if we have non-compliance with this licensing regime, for example, a failure to obtain a licence, it's accompanied by criminal sanctions, up to 5 years imprisonment. So it's quite significant and a deterrent if you want to actually use CRISPR technology and you're unsure about. If we move to the REACT, this was prompted by advancements in cloning, namely Dolly the sheep. It also responded to research advancements within stem cells and how they might be used within an assisted reproductive technique. So largely the rhetoric in Australia was a concern that we would use human cloning as part of human reproduction. So this is an example of a public policy area that was very much socially and ethically provocative. And we saw not only within media, but also within our parliamentary debates, it was all concerning the moral status of a human embryo. So that dominated the debates and the rhetoric. And unfortunately, as a result of that, the technical aspects of the science and its potential uses or advancements to the field of medicine were either sidelined or silenced by lawmakers. So as a result, the REACT is very conservative, it's careful, and it's very strict. And interestingly, the REACT does allow very limited research uses of a gene technology in a human embryo. And the primary driver for this was a prevailing duty to society to enable this research to continue. So it's an interesting example where we see the tension between very much ingrained norms or values and beliefs and the need to perhaps challenge those views in order to facilitate development of a technology with a view to hopefully the betterment of public health. So in terms of the regulation of heritable human genome editing under this particular Act, similarly we've got a licensing regime, and that's enforced through the Embryo Research Licensing Committee. We have a very broad definition of an embryo, which enables its use for research and training within an ART on egg culture, manipulation and maintenance. And there are two limited circumstances where we can use CRISPR technology. Pursuant to a licence, the committee may authorise it for mitochondrial donation. So very recently in Australia, that was legalised. And the second is using it as part of research on excess embryos or embryos that are not suitable for implantation. This latter example is also introducing a number of administrative burdens to actually undertake this research. For example, explicit written consent must be provided by the woman and her partner at the time that they engaged with that service. They have to declare them as excess embryos or embryos that are unsuitable for implantation. And then that goes to the committee and they have to authorise it. So that can take quite a bit of time and it's relatively tedious. The other problem is that it already undermines the value of the scientific research that could be undertaken on these embryos. So the utility of that research is questionable because if we're dealing with an embryo that is unsuitable for implantation, it's likely one that is not capable of properly sustaining life to function. So that is perhaps one of the limitations of undertaking research on one of these embryos. And what this Act has shown us is that we do have a very restrictive regulatory environment. We have a very limited scope that seems to enable us to lawfully use CRISPR technology within a human embryo, but it is very much still driven by ambivalence and it's certainly a deterrent for researchers because they find this very difficult to navigate. One point I want to raise from the third International Summit on Human Genome Editing last year in London, and I was very fortunate to attend in person, is that the organising committee released a concluding statement, and they recognised the invaluable progress of germline editing within a research context. And a lot of the discussions at that meeting also highlighted that we've been in this position before, even with somatic genome editing, when it was nearing clinical trials. There was similar apprehension and fear and the need to regulate and address its future uses. But had we not enabled that research to continue, we wouldn't be in a position now where very recently, late last year in December, we had the very first FDA-approved clinical trial therapeutic that uses somatic genome editing to cure sickle cell anemia. So there are untold possibilities, particularly with heritable human genome editing. But that's not to say that we should allow it in every single way or application, but we certainly need to start turning our minds, particularly in Australia, to a more appropriate course of action to regulate its potential uses in humans. The final act is the PHCR Act. This was developed in tandem with the REACT, and they ended up splitting those two bills because it was incredibly provocative in terms of the issues it raised around human embryos. And similarly, this act was described as conservative, and we see it is incredibly prohibitive. Heritable human germline editing is completely in contravention of this act, and it's accompanied by significant criminal sanctions. We see this in two provisions of the statute. The first being Section 15, where we have any heritable alteration to the human genome is completely banned and may have 15 years of imprisonment if undertaken. So the effect of the provision, we ban germline editing, we criminalise it, particularly in the clinical context, and we significantly limit its research application. The second provision, under Section 20, subsection 3 of the Act, is placing a prohibited embryo. A prohibited embryo is one that has been subject to CRISPR technology. If an edit has been made in an embryo and that's subsequently implanted into a woman to achieve a pregnancy, this also carries a sentence of 15 years imprisonment. I put a note here around the Lockhart Review, and this was the first and only statutory review of the REACT and the PHCR Act. Interestingly, one of their recommendations in that review was that using a technology like CRISPR, obviously at the time it wasn't yet discovered, but using a technology other than fertilisation of an egg and a sperm cell should be undertaken in a research context to better understand disease development, but also to enhance our knowledge and understanding of early human development. And this is very much the position that we've seen adopted in the UK, and even last year at the third summit, that was reinforced in the concluding statement. So we are yet to see the practical implementation of that particular recommendation, and that was made in 2005. So when we're looking at heritable human genome editing, it's starting to strengthen its case as a potential therapeutic candidate to either prevent or treat genetic diseases in humans. And when we enter the realm of clinical trials, this engages, in Australia, the Therapeutic Goods Administration. And they are our primary regulator that's tasked with quality assurance of new therapeutics, and they essentially manage and regulate all of our clinical trials. Under our law, genetically modified cells are classified and regulated as a class 4 high-risk biological. And that's mostly because of the uncertainty attached to these types of new treatments or drugs. We had the introduction of a new scheme called the CTA scheme in Australia, and that was pretty much adopted to address new technologies. And one of the overarching purposes of this scheme is to try and encourage the entry of new drugs or devices using new technologies with a view to prevent disease or replace and modify the anatomy of the person, which extends to our DNA. If we want to proceed with a clinical trial that involves a Class 4 high-risk biological, we would need approval from the Gene Technology Regulator, the Therapeutic Goods Administration, and the relevant institutional human research ethics committees. And I'll note, the PHCR Act and the REACT and the non-binding policies or codes of conduct continue to operate at the periphery. And this leads me to my conclusions in my article around Australia's regulatory approach. It is a highly complex system to navigate, and it's representative of a piecemeal approach to regulation. It invokes a number of different acts that all attempt to identify the boundaries of acceptable uses of genome editing. And that's also reflected here in this graphic, where we see there are overlaps between each statute, but yet there is not a single statute that necessarily addresses heritable human genome editing or its potential use. So this really does highlight, again, that innate reality that the law lags behind science. It attempts to catch up with science, but what that means in terms of law reform is that it can be difficult to future-proof the law, so that we end up with a legislative and a regulatory landscape that is inherently malleable to adapt to these various advancements. This led me to identify 3 shortcomings in our current landscape, or gaps. The first being regulatory complexity. There is no single statute which specifically addresses heritable human genome editing, whether it's in a clinical or research context. And we see that our regulatory approach is administered through various statutes. The second is legislative ambiguity. So the lack of prescriptive statutory language creates a large degree of uncertainty around the practical operation and enforcement of various provisions. And finally, there are inconsistent legislative objectives. So the governing statutes are theoretically not fulfilling their objective. And this may indicate that perhaps they're no longer fit for purpose, necessitating a review. If we look at the first shortcoming of regulatory complexity, this raises questions around the formal regulators. Who would they be? We've got multiple regulators already, like the Gene Technology Regulator, our ethics committees, the Therapeutic Goods Administration. Each have distinct roles and responsibilities. So who will be undertaking what responsibilities when we deal with heritable human genome editing? We see that the Gene Technology Regulator retains its status as the primary body to regulate a gene technology. But if we are proceeding with a clinical trial that involves a CRISPR therapeutic, we still require a licence or an exemption from the Gene Technology Regulator, despite it being largely silent in the law. So, should we infer that a human embryo does in fact constitute a genetically modified organism for the purposes of the Gene Technology Act, where we do have a CRISPR technology applied to that embryo? And we also need to be cognizant of the fact that we need to share this responsibility with the Therapeutic Goods Administration, because we intend to use it as a therapeutic good in Australia. Our complexity is further perpetuated by the REACT and the PHCR Act, which are incredibly prohibitive and a hindrance to Australian researchers who would like to engage with CRISPR technology. The difficulty with the REACT is that we need to rely on human embryos if we want to try and use heritable human genome editing for a research purpose. So we engage the regulatory system under the REACT as well. So we have a number of statutory responsibilities and obligations that we need to be aware of if we want to undertake research. And I have an example here. If a researcher would like to use CRISPR technology in a human embryo, they must actually be aware of the constraints and the statutory obligations imposed by the triad of governing legislation and the Therapeutic Goods Act, if it's relevant. So that means that the researcher must ensure they have licence applications from the relevant authority or authorities, could be plural, and they need to understand the statutory limits on acceptable research purposes. All the while, they have a threat of criminal sanctions, which are quite significant. So we see that perhaps this complexity could strengthen a case to argue a single legislative instrument may be warranted in Australia that specifically addresses heritable human genome editing at each stage, whether it's the research, the preclinical, clinical, and actively addresses the translational pathway from bench to bedside. If we turn to the second shortcoming, legislative ambiguity, Section 15 of the PHCR Act is quite an apt example. And this is looking at any heritable alteration to the genome is accompanied by 15 years imprisonment, potentially. And note here in provision C, we accommodate mitochondrial donation. So that is still lawful. This particular provision applies to both embryos and gametes. Gametes are eggs, sperm, created by fertilisation or some other means. And that other means might be CRISPR technology. So again, we see there's a contrast between our current law and the Lockhart Review, which was recommending for the use of new technologies as they arise to be applied in a research context. Another point of ambiguity refers to the fault element of this provision, and that element is an intention for a heritable alteration. How can this be interpreted? Does it mean that it is an intent to create a heritable alteration merely by the creation of the CRISPR complex, the guide RNA construct, and the DNA sequence that we would like to rely upon when we repair that double-stranded break, meaning we introduce a new trait or a corrected gene? Or is it referring to an intent to pass on a specific genetic alteration? For example, if I wanted to carry out, in a research context, ways in which we can use heritable human genome editing to correct the gene that confers cystic fibrosis. Is that the intent required to satisfy the fault element for this provision? Merely that I have chosen cystic fibrosis and will use CRISPR to correct that gene, to remove that predisposition to cystic fibrosis. This becomes quite problematic, this legislative ambiguity, because we are dealing with significant criminal sanctions. And of course, for a researcher who may not be completely comfortable or aware of the law and the statutory limitations, it is certainly a deterrent. And finally, inconsistent legislative objectives. So what we saw in the first part of the presentation was essentially a very short policy brief of each statute. Each of the triad of governing legislation, those statutes were developed at a time in which CRISPR technology within humans had not been foreseen and it had not yet been discovered. So of course it was developed to address various other concerns or uses of a gene technology, namely in agriculture and food. And this is reflected in our objects provision of each statute, When it comes to the Gene Technology Act, it's very much plant-centric. It has a focus on environmental harm and human harm in the context of consumption of a genetically modified organism. If we look at the REACT, this is responding to advancements in research techniques that involve human embryos, but it was dominated by a moral debate around the status of a human embryo. And that's reflected again in Section 3, the object of the Act. If we actually look at this particular provision, it leads to at least a foundation to make an argument that perhaps the REACT could be an appropriate legislative home for heritable human genome editing because it's looking at applications of human reproduction and assisted reproductive techniques. And finally, the PHCR Act, again, was quite clear in its intention to criminalise and ban human cloning, and certainly the use of human cloning for a reproductive purpose. Overall, it was very difficult for lawmakers to foresee heritable human genome editing and look at ways in which the law could be flexible to accommodate potential advancements in the space of gene technology. And rather, what we've seen over time is a piecemeal approach to regulation. Each statute has been reformed to try and respond to recent developments, but gaps still exist. And certainly from an operational standpoint, it's very difficult to see how this might all come together if we do end up with a clinical trial that involves some type of germline editing therapeutic. In terms of where to from here, it's certainly cause to consider whether Australia's legislative and regulatory landscape is adequately equipped to address future applications of heritable human genome editing. And of course, this would require a review of the statutes, and a more recent review for that matter as well, with a focus on interactive effects, whether it be with other federal statutes, but also the role of state-based statutes. So in Australia, we have a federal system and we're governed by federal statutes, but each Australian state has enforced their own state-based statute, which is largely a mirror of the federal piece of legislation. But still, we need to look at those interactive effects. Perhaps we can look at other jurisdictions, like the UK, which historically has been more progressive in this space, particularly with genomics and research. And perhaps some lessons can be learned from the World Health Organization. In 2021, they released the Human Genome Editing, a framework for governance, and that was piloted last year in Uganda. So there may be some important lessons around an appropriate regulatory mechanism that we could adopt and tailor to our jurisdiction in Australia. Finally, past experience in developing policy and law within the field of an emerging technology should inform our next steps to help future-proof Australia's laws. We've certainly been here before, with in vitro fertilisation, for example, mitochondrial donation more recently, which are now socially accepted technologies. And at the time of their inception, we faced similar concerns around uncertainty, issues of safety, data gaps, knowledge gaps. But if we proceed with precaution in a way that will help facilitate responsible research and innovation, we would be in good stead. And of course, we also need to consider the ethics attached to our regulatory decision making. Thank you very much for your time.